Yeah, I mean, in India, we also have the requirement of providing statement and undertaking for foreign filings and the status of the respective application in other countries. That's also one of the ground for the objections as per the law. So I think that should also be taken care of. But apart from that, US, Europe, any specific thing which you would like to highlight, which one should be aware about, which is like a pitfall?
So it's completely understandable why this happens, especially coming from jurisdictions that don't allow claim amendments after filing or only allow narrowing claim amendments, and also for cost reasons. But sometimes I see applications come into the U.S. that are extremely thin, right? So they have enough support for the claims and very little else. That's really hard from a U.S. standpoint because in the U.S., you can put the kitchen sink into the application and then draw anything from that sink to put into the claims to overcome a rejection. And so filling out if you know you're coming to the US, then filling out the application, the specification I should say, with as much detail as possible, alternatives, different levels of detail, all of that can be very helpful in terms not just of getting your first patent issued, but then filing a continuation, which again is somewhat unique to U.S. practice, but filing a continuation, whether that's to keep an application alive so that you can go after competitors if and when you need to, or to build out what we call a patent thicket to make your position stronger if you ever do have to enforce that application.